Yeah, it looks like we're more or less there in terms of people arriving from the waiting room. So I'll get started. Thanks very much to everybody for coming to Doughty Street's annual roundup of homelessness law in 2020. It's obviously been an interesting and important year in relation to homelessness, as in relation to so many other areas, because of the effects of the pandemic. And to some extent, there's been a real opportunity to take radical action with long stays of evictions, provision of accommodation for rough sleepers under everyone in. However, also the everyone in scheme particularly has perhaps illustrated some of the old familiar difficulties that I think Alice is going to touch on very briefly. And the pandemic seems to have made some other issues more acute in terms of issues about suitability of accommodation provided, for example. So there's plenty to deal with, and in fact today is the first of 3 sessions that Doughty Street are going to be given in relation to homelessness over the coming fortnight. So today we have our now traditional annual review of the developments generally over the last 12 to 14 months. On Monday, the 1st of February, Sarah Steinhardt, David Carter and Ben Chataway are going to be having a look at where things are up to in relation to the Homelessness Reduction Act, and what challenges have been brought and what challenges are still there to be brought that don't seem to have been picked up yet. And then the following Tuesday, on the 9th of February, Martin Westgate, Simon Cox and Marissa Cohen will be looking at the question of eligibility now that the Brexit transition period has come to an end. So hopefully you can all join us for at least one or other of those. So turning to today's proceedings, here to guide you through the ups and downs of the past 14 months or so, we've got 2 members of Doughty Street's housing team. First, Dominic Preston, most of you will be familiar with. He's an extremely experienced practitioner, not only in homelessness and housing law, but also in connected areas such as community care and court of protection work. He's recognised as a leader in housing law in the directories. He's appeared in a number of the key cases in relation to housing and homelessness, and he's written various books and articles in the field, and I'm sure he'll be dying for me to stop there and not embarrass him further. So I think he needs no further introduction. Alice Irving is the newest recruit to the housing team at Doughty Street. She's arrived with a wealth of experience both as an academic, having previously worked at Oxford University and the Law Commission, and as a practitioner with particular expertise in relation to women's rights and disability rights issues. She also has written for various publications, and she tweets relatively prolifically, I think it's fair to say, on recent developments in the area under the Twitter handle Alice L. Irving, which I would recommend you all follow. So without wanting to use up any more time on introductions, just a couple of very quick housekeeping matters. Paper for today has been made available at the link which has been posted in the chat. So if you click that link, you should be taken to a page where you can download the handout for today's session. In relation to any questions, we're going to propose to deal with those after both presenters have spoken. And if you can put your questions in the Q&A function, which you should see at the bottom of the screen, pop them in there as they occur to you as the session goes on, and then we'll have a list of those that we can come to at the end and direct them to the relevant speakers. So with that, I'll pass over to our first speaker, which is Alice.
Fantastic. Thanks very much, Dan. We have a lot to get through today, so I'm going to get cracking pretty much straight away without much preamble. Here's a slide that just has my name on it. And here, very briefly, I'm going to speak about the rough sleeper initiatives that have been rolled out in the context of the pandemic. As flagged by Dan, there's going to be a much more thorough treatment of issues arising in relation to eligibility and also some of the issues that have been highlighted in the context of the pandemic in the third of the webinar series. And one of the key things that's arisen in this context, and I'm sure that many of you practicing in the area will have come across this, is the interaction of everyone in with eligibility requirements under Part 7 for assistance. So just a very quick kind of run through what happened with everyone in. And 26th of March 2020, the MP Luke Hall wrote to local authorities, and at that stage they were being told to utilise alternative powers and funding to assist those with no recourse to public funds to be given shelter and accommodation and other forms of support. So we started out with a fairly clear message that NRPF wasn't meant to sort of stand in the way of getting everyone in. But by 28th May 2020, when a follow-up letter was sent out to local authorities, things had started to shift a little. So at that point, the initial phase of everyone in had been completed, and lots of people had been brought in off the streets. And then local authorities were asked to develop plans to show what they were going to do next in terms of getting people into move-on accommodation, how things were going to be taken forward. Now, in the paper that you can download, you'll see that just this month, the National Auditor's Office has carried out a review of an investigation into the response to rough sleeping during the pandemic. And they note that at this point in sort of late May, when this letter went out, what happened was there was a divergence of approaches taken by local authorities in relation to people who were ineligible for support. Some of them kept everyone that they brought in emergency accommodation, regardless of their eligibility, and other councils started to try to move people out of emergency accommodation if they weren't eligible for Part 7 or any other support. What the letter on the 28th said about people without eligibility was basically that it was up to local authorities to use their judgment about whether there was risk to life, and they drew an analogy with the work that's done to bring everyone in when there's extreme weather conditions and risk to life. But that was obviously a fairly vague kind of guidance to local authorities. And as we say, the National Audit Office has found that there was a divergence of opinion at that point. Then on 22nd of September 2020, another ministerial letter was sent to local authorities. And at this point, it was affirmed that local authorities must ensure that support offered to non-UK nationals complies with legal restrictions in the legislation. So we've seen quite a shift in tone from that first letter that was sent out to local authorities saying, get everyone in, even if they are NRPF, through, risk assess individuals through to comply with legal restrictions. One of the things that came out of the National Audit Office report was that one of the key issues was that people with no recourse to public funds were having challenges, obviously, moving into settled accommodation on a long-term basis because they couldn't get Part 7 support. They couldn't get benefits to help them into the private rental sector and so forth. And one of the things flagged to the National Audit Office in their conclusions was that this was something the government needed to decide what it was going to do in relation to this cohort. And we're yet to see that report just came out on the 14th of January. We're yet to see what comes about in light of that. But one thing I would flag is this case here that's on the slide, Brighton and Hove case. So just before Christmas, there was a challenge that went to the High Court and was heard in relation to whether local authorities have a power to accommodate those who are not eligible under Part 7, who had been brought in and under everyone in, and then a local authority tried to say, okay, we can't provide you any further support. And there was a question as to whether, for example, a legitimate expectation of being housed had arisen, and whether there was a power actually that a local authority could use. And that's a case that Martin Westgate QC was leading on, and he'll be speaking about in that third webinar. And hopefully by the time that third webinar comes around, there will be a final decision in that case. Moving on then to sort of the nuts and bolts of homelessness law, and sort of the general roundup that we're doing rather than the COVID-specific roundup. The first area to cover are sort of those initial procedural aspects. So talking about applications, and the one case that's come through in the last year of interest in this area is the Bucaratic case. Perhaps I'm saying that wrong. Forgive me if I am. And this addresses the idea of when a repeat application has to be accepted by a local authority. So I'm sure you're all familiar with Rika Begum, which basically says that a local authority must accept a repeat application as long as that application isn't made on exactly the same facts as a former application that's been rejected or dealt with previously. And so in this case, before the High Court, which was heard actually at the very end of December 2019, that wasn't caught in the last roundup, the question arose whether things were being just sort of the application was on exactly the same facts. the basic factual background here was that the applicant for Part 7 support had sought priority need on the basis of mental health issues. But when she first made an application, she'd refused a referral to a mental health team for assessment, and she'd also failed to provide any documentary medical evidence to support that she had priority need on the basis of a mental health issue and vulnerability. So that decision went against her and was upheld on review. She made a fresh application under Part 7, which was then supported by letters from a psychiatrist setting out her mental health position, but the local authority refused to accept this on the basis that they say it was an application made on exactly the same facts. This led to a judicial review and this case here, which has been reported. What the local authority were effectively saying was that they were fully aware at the time of the first application that the claimant or the applicant had low-level mental health problems, because despite the dearth of documentary evidence she had provided, they had notes on a housing file pointing out that there were a number of issues. And so they already knew that, and they'd made the decision they had on priority need on that basis, and therefore the fact there was this new evidence didn't really change the situation. Now, that argument was rejected roundly by the court for a number of reasons, and they were fairly critical of the decision-making of the local authority. The first of those reasons was that it's not the case that they'd made the first decision on the basis that, oh, we knew you had a low-level mental health need, but we decided that that didn't qualify for priority needs. The first decision, and it was quite clear from the documentation and the reasons given, was made on the basis that there was no evidence of her mental health condition, and therefore that they didn't accept she had a medical condition that might be linked to vulnerability. And the court emphasised that in Rika Begum at paragraph 60, what's really important is whether the facts that were raised previously were both known to and taken into account by the authority at the earlier stage in time. So the fact that the local authority might have been aware from the housing file notes that there was a mental health issue in the background here didn't mean it had been taken into account in the decision in the way which barred it from sort of being raised as fresh evidence in a subsequent application. Secondly, the court held that it was irrational, effectively, for a local housing authority, having decided to reject an application on the basis of a lack of medical evidence, to say that new medical evidence wasn't a new fact they had to take into account, or that it was trivial and not significant enough for them to have to accept a fresh application. So that wasn't accepted either by the court. And finally, the reasoning of the local housing officer who'd refused the application was very critical as well, on the basis that basically the local housing officer had gone through the evidence from the doctors that had been provided and cherry picked out the bits that helped to show and to make the argument that basically nothing much had changed without really looking at things in a round. And the court said that that wasn't acceptable either. So a fairly strong and robust decision there about this idea that an application can only be refused if it's made on exactly the same facts, making it fairly clear that if there's fresh evidence to support an application, that's very, very likely to mean that the application should be accepted. Right, so moving along then to priority need as a substantive topic in and of itself. We've had a couple of updates, and a lot of those are actually in the context of COVID and are quite interesting. But before we get onto that, we've had some more clarification from the courts in relation to how the public sector equality duty under the Equality Act sits alongside the vulnerability assessment required under 189(1)(c). In particular, I'm sure that you're aware from the case of HOTAC, we know that when we make a decision about vulnerability, or when a reviewing officer does that they're required to focus sharply on 4 questions if the public sector equality duty is engaged. And the first of those is whether the applicant is under a disability. The second, the extent of such disability. The third, whether the effect of the disability is likely to mean that if and when homeless, that individual sort of is in a position that's different to somebody else who might have been made homeless, an ordinary homeless person. And fourth, whether the applicant is vulnerable as a result. So what we had in the case of McMahon was a bit more detail about precisely when a reviewing officer can be said to have complied with that obligation to take into account the public sector equality duty. And what's really clear, again in the case, is that this is always going to be a matter of substance rather than form. The Court of Appeal roundly rejects the suggestion that those 4 steps identified in HOTAC have to be gone through like a checklist or even averted to expressly by a decision maker. That's not necessary at all. In fact, it's not necessary for there to be an express finding one way or another by the reviewing officer if it's a Section 202 review as to whether an individual has a disability or not. It's enough for the reviewing officer to have looked quite closely at the mental or physical problems that the applicant suffers from, and then to look at how that impacts on what would happen if they were homeless. And if a reviewing officer's done that, it's very likely that they've also discharged their public sector equality duty. And finally, again, sort of pointing out a very pragmatic approach is being taken. The local authority rejected, the Court of Appeal rejected the idea that there had to be a really broad consideration by a reviewing officer of the impact of disability on a person's life. So under the Equality Act, when you're thinking about whether somebody's disabled, you'll be asking what the impact of their condition is on their day-to-day life generally. And so you might say things, for example, like, well, they're unable to stay and work, and indeed, one of the appellants in this case couldn't work. When it comes to considering whether somebody's vulnerable, the question is quite narrowly focused. It's not to do with the impact on somebody's day-to-day living generally, but about their ability to cope if they were made homeless. And for that reason, the court affirmed that it's not necessary for a reviewing officer to consider all of the other incidences of disability. If it was irrelevant that the person was unable to be in work for the purposes of deciding whether they could handle being homeless, then the reviewing officer didn't need to refer to the fact that they were unable to work because of their disability. So a very pragmatic approach there from the Court of Appeal, very much in line with HOTAC and saying that, you know, more often than not, if somebody's gone through the vulnerability analysis closely, they'll probably have discharged the public sector equality duty in doing so. And we're not looking for some kind of arid, rigorous application of a legal test. Moving on then to other developments in relation to priority need, particularly in the COVID context. Now, what's not up on the slide here is that Chapter 8 of the Code of Guidance for Local Authorities was actually updated by the government in response to the COVID-19 pandemic expressly, and this is in the paper. But at pages 8.44 and paragraph 8.45, it makes fairly clear that housing authorities, when considering the vulnerability of applicants, need to take into account COVID-19. In particular, it's going to be relevant to consider whether somebody's been identified as extremely clinically vulnerable or clinically vulnerable. And this becomes relevant in the next case that I'll be discussing, which is the Bancol-Jones case, which went to the High Court. In this case, it was argued on two different bases that a person who was rough sleeping had priority need. Firstly, that they were vulnerable under Section 1891C, and secondly, that they were homeless as a result of an emergency under Section 1891D. Both of those arguments failed before the High Court. So just unpacking that a little bit and discovering what that tells us about the approach to priority need in the context of the pandemic. So when it came to Section 1891C, the argument before the High Court was effectively that all rough sleepers should be classed as vulnerable because of the risk that was posed to them by the COVID-19 pandemic. They were at a heightened risk of contracting COVID-19 if they were rough sleeping. And that should be enough to bring them within the vulnerability category under 1C, and therefore they should have priority needs. Now, this was rejected out of hand by the High Court on the basis that it's clear the legislative language of 1C focuses on whether an individual is significantly more vulnerable than an ordinary person when homeless, and that had been affirmed in HOTAC. And it wasn't possible or right to introduce a further distinction into that legislative test to say, well, is this a rough sleeper or some other kind of homeless person? So that wasn't an appropriate way to move forward. And the High Court very much affirmed the approach taken in the update to the Code of Guidance in England, which was the relevant question is to look at this particular individual and to see if they have a particular vulnerability themselves to COVID-19 that has to be taken into account when applying the conventional HOTAC test. And in this case, there was no evidence that the applicant himself had an underlying health condition which gave rise to any particular concern. and for that reason, they were unsuccessful on the first argument. The second argument under section 1891D was a little bit more complicated. So the applicant in this case had been residing at a YMCA in shared accommodation, but he had been asked to leave because of poor behaviour. Nevertheless, the argument being run before the High Court was that if we just ignored the poor behaviour, his accommodation at the YMCA would have become unreasonable for him to continue to occupy when the pandemic began, because it was shared accommodation, and shared accommodation was a dangerous place to be during a pandemic because you couldn't socially distance and so forth. So they said the effective cause of his homelessness is that, you know, leaving the bad behaviour out of the picture, that the YMCA would have become unreasonable to occupy as a result of the pandemic. Therefore, he was homeless as a result of an emergency, the emergency being the pandemic. Now, unfortunately, perhaps for clarity on the legal front, this argument hadn't been made to the local authority at the review stage under section 202. There had been a different argument advanced under section 1891D, but it was accepted by the time we got to the High Court that that argument couldn't work. And so the High Court refused basically to uphold the appeal point on section 1891D on the basis that there was no material error in the review decision because they hadn't considered this new argument. The argument wasn't so obvious that the reviewer should have dealt with it, and you couldn't just raise a new point on appeal. So on that basis alone, section 1891D argument just faltered. Further, the court noted that there was no evidence that shared accommodation, or the YMCA accommodation in particular, would have become unsuitable or unreasonable to continue to occupy, and it wasn't sufficient to make a general assertion that shared accommodation was unreasonable to occupy in the context of the pandemic. You needed more specific evidence than that. And the court refused to provide an overview, therefore, on whether the pandemic was an emergency within the definition or meaning of section 1891D, or whether there was a causal link between the pandemic and the applicant's homeless. So we didn't really get any answers here, although it is worth noting, and it's set out in the paper, that it's not clear whether the case of ex parte Braddock was brought to the attention of the court. And in Braddock, they did deal with this idea of what kind of emergency falls within the scope of subsection D. And Lord Justice Roche there said that it would be emergencies which cause physical damage to accommodation, rendering it uninhabitable. So there are sort of questions about whether the pandemic would fit into the definition of emergency anyway, but we didn't get any clear view on that because the appeal failed on other grounds. And finally, in sort of related decision about COVID-19 is the case of Kayaks and Westminster Council, which is reported in Legal Action Group. This was before the County Court at Central London, and this involved an applicant who had a number of physical and mental health conditions, which she had disclosed in her application to the local authority. There were a lot of grounds on appeal in this case, and a lot of them were successful. I'm not going to go through all of them, but I'm going to focus specifically on the ground that related to COVID-19. So the kind of chronology for the purposes of this case was that the applicant had applied for support under Part 7 prior to the pandemic really kicking off in the United Kingdom, and she'd been found to not have priority need. She then applied for a review under section 202, and it was about the same time as she applied for the review that the pandemic started to emerge and was sort of in full swing in the UK. The reviewer had concluded again that she didn't have priority need, but in making that decision, the reviewer made no reference whatsoever to COVID-19. And the question was whether or not that was an error of law on the part of the reviewer, such that it could be a successful ground for appeal under section 204. And the court concluded, yes, it could be. And in the particular facts of the case, they held that because of the applicant's array of medical conditions, which the reviewer was aware of, the impact of the COVID-19 virus was a relevant consideration that should have been considered when determining whether the applicant would suffer or be at risk of a particular detriment if she was rendered homeless. Any reasonable reviewer faced with an applicant who had an array of major active medical complaints would have made further inquiries in relation to the interaction between those medical complaints and COVID-19. And so in this case, it didn't matter that the reviewer hadn't been provided a letter, for example, from the applicant's GP stating she was clinically vulnerable or otherwise. It was enough that they had this information about her medical conditions. They knew COVID-19 was afoot. The reviewer should have made further inquiries, and the failure to do so was a legal error. So that's quite useful, obviously, if you come across a similar case where COVID-19 hasn't been taken into account. But I'm not sure it goes as far as saying that COVID-19 is always a relevant consideration. It's still factually sensitive to whether the individual perhaps has a medical condition which makes COVID-19 particularly relevant. Moving on again to my last slide before I hand over to Dominic, and I take a breath because we're ripping through this at quite the rate. I hope you're sticking with me. So looking at intentional homelessness, there are a couple of cases this year, neither of which are COVID specific, that are useful updates. The first, Albion Tower Hamlets, which I understand actually Daniel was a junior on, so he can correct me if I get something wrong in relation to this case. This was an interesting case about when somebody was intentionally homeless or not in the context of domestic violence. And what was unusual about the case was that the applicant had been evicted because she was in rent arrears, but that had happened in the context of a history of domestic violence perpetrated by her ex-partner, her ex-husband, against her. And the court said, well, section 177, which is the dealing provision, which says it's unreasonable to continue to occupy property if it's probable that that will lead to a risk of domestic violence. The court said, well, that's quite easy to apply where you've just got domestic violence in the picture, when somebody's saying, well, I left the property because of the risk of harm. But it's a bit more complicated, whereas here, the individual left because she was evicted due to rent arrears, but there's this background of domestic violence also in play. And so the question was, well, how should that kind of set of facts have been approached by the Section 202 reviewing officer? And a couple of really interesting points arose in this regard, because at the time the applicant had applied for support initially, I think everybody agreed that it couldn't be said it was unreasonable for her to continue to occupy the premises on the basis of domestic violence. At that point, there hadn't been an incident for quite a long time, and she herself said she was content to stay in the property and didn't feel at risk of harm there. However, by the time it came to the decision of the reviewer, a number of further incidents had occurred that were in relation to her ex-husband, which had kind of changed the scenery. So one of the key questions before the court, alongside, well, what do we do when we've got rent arrears complicating the picture, is, well, can we take into account these things that have happened after she applied for support, but before the review decision? So if you'll bear with me, it's kind of a bit complicated, but what the court ultimately said was that the question to ask was whether or not it was reasonable for the applicant to have continued to occupy her old accommodation at the time that she did the thing that meant she had to cease accommodation, so it ceased to stay in the accommodation. So at the time, she fell into rent arrears and therefore was evicted. Was it reasonable for her to continue to occupy that accommodation? But in determining that, you could take into account all the information before the reviewing officer, including incidents up until the time of the reviewing officer's decision. So in deciding whether it was reasonable for her to continue to occupy at the time that she fell into rent arrears, the reviewing officer could take into account the events that occurred subsequently. So the things that happened with her ex-husband since then that suggested that there was a risk of violence to her. That's a bit of a tongue twister. It might be worth looking at the paper itself just to keep that kind of clear in your head. Ultimately, the appeal failed on the particular facts, but I think it's a useful and interesting clarification of the way that you approach sort of the relevant factual matrix when it comes to deciding how Section 177 applies. And the court was also very clear that, you know, while you were looking at the pinpoint moment in time when she did the act of falling into rent arrears, that, you know, that was the moment you were asking, well, was it reasonable for her to continue to occupy the accommodation? When you were carrying out that Section 177 inquiry, you ignore the fact that she is, you know, in fact not paying rent. You just take that as the moment in time. Another point that was raised in the case that's not developed in the paper that's in the handout, but it's also worth noting, is there was some criticism of the reviewing officer's decision on the basis that they seem to be looking, arguably, at whether or not there was a risk of future violence occurring at the property itself in particular, rather than whether there was a risk of future violence arising if she continued to occupy, whether that violence happened at that property or somewhere else. And the court affirmed that the correct approach is it probable that there would be domestic violence if you continue to occupy, but that violence wouldn't need to occur at the actual property itself. But again, on the facts, they found that the reviewing officer hadn't made that mistake. It's a curly one. Thanks for bearing with me. And as I say, do have a look at the paper for more detail on that. In relation to the final case I'm going to cover, which is Doughty and Westminster Council, this relates to the question of when someone's accommodation can break a chain of causation between them becoming intentionally homeless and then a subsequent sort of Part 7 application. So you'll know that the way that this works is if somebody's done an act, which means that they're intentionally homeless, and then they later again make a Part 7 application, it's relevant to ask, well, has there been anything that's changed the position? Is their current homelessness still a result of that intentional act, or has something changed the picture and broken that chain of causation? And one of the ways in which that chain of causation can be broken is if the person's been in settled accommodation since they were last found to be intentionally homeless. And the case of Doughty in particular addresses what might qualify as settled accommodation. So in this case, the applicant, she had previously applied for Part 7 support, and she'd been offered suitable accommodation, which she had turned down. And at that point, that meant she was considered to be intentionally homeless. After turning down that suitable accommodation, she and her 3 children, 2 of which were adult children, and one of which was an adult and 2 of which were teenagers, moved into a 1-bedroom flat, which was therefore statutorily overcrowded. And that flat they occupied on the basis of a formal lease on a commercial basis with a commercial landlord, which then became later on a periodic tenancy. And they were at that property for just over 2 years when the landlord sought possession and they again became homeless. So at that point, she again applied for Part 7 support, and the local authority said, no, you're still intentionally homeless because this wasn't settled accommodation. The accommodation was statutorily crowded for the whole time, and so it couldn't break the chain of causation between her previous act of refusing appropriate support and her current homelessness. This went to the Court of Appeal, and the Court of Appeal found that the reviewing officer had made an error of law in the way they'd approached this. So the Court of Appeal reasserted a lot of what we already knew, which is what amounts to settled accommodation is always going to be a question of fact and degree. And there are a lot of different factors to take into account, including whether it's the accommodation is occupied on the basis of a lease or a license, how precarious it is, whether the arrangement is a commercial one or an informal one, say with a friend or family member, whether the accommodation is affordable, whether it's overcrowded, and so on. The problem here was that the reviewing officer had focused solely really on this point of overcrowding, and on that basis had said, well, therefore, this was always going to fail or bound to fail as a stable accommodation arrangement, and so this was never settled accommodation, which could break the chain of causation. This was a problem on 2 fronts. So first of all, there'd been a complete failure to consider other relevant factors, and many of those relevant factors pointed in the other direction. So the fact that this was a commercial relationship, that it was stable for a long period of time, and so forth. And secondly, that the reviewing officer had just kind of said, oh, overcrowding is a problem, but hadn't really fleshed out how that related to the question of why the accommodation was or wasn't settled, or whether or not the accommodation was temporary. So the kind of takeaway here is that the reviewing officer should be looking at all the factors in the case and explaining how those factors relate to their overall conclusion as to whether accommodation is settled or whether it's temporary. And in this case, they hadn't done so, and they'd therefore erred in law, and the decision was quashed. I think really importantly, what comes out of this case is that just because accommodation is statutorily overcrowded from the outset, it does not necessarily mean it won't be settled accommodation for the purposes of breaking this chain of causation in the intentional homelessness context. So overcrowded accommodation might be, as it was in this case, all that an applicant could afford, given their financial means and the state of the market. And so the kind of assumption that, you know, this couldn't possibly ever be settled accommodation that was made by the reviewing officer was wrong. So if you do come across that in a case, this is the reference for you from the Court of Appeal. I'm going to take a deep breath now and hand over to Dominic, who has the pleasure of going through the more substantive aspects of homelessness law and how they've changed in the last year. Thanks, Dominic.
Thank you very much. So Alice is in control of the slides, so I'm going to ask her to pop to the first slide if that's okay. Thanks so much, Alice. Just before I start, just to say, although I've included quite a lot of slides, quite a lot of cases on the slides, I think I'm going to try, looking at the time, to skip some of them. So I hope you'll forgive me if I don't deal with every case on the paper. Dealing first with Homelessness Reduction Act, we do have, as you heard from Daniel, three sessions dealing with homelessness, and the second session will deal with this topic. One of the oddities about this particular topic is there aren't that many cases which have been reported, which are giving us guidance on some of the issues that are coming up. And that's why we want to deal with this particular topic in an individual seminar, so as to try and work out where those potential appeals can take place and where those potential cases come from. So the information I have at the moment is really in relation to what the government says about the impact of the Homelessness Reduction Act. We've all got used to new concepts over the last 2 or 3 years. Threatened with homelessness has a new definition, personalised housing plans, new prevention duty, new relief duty, new local connection concepts. And with all of those new concepts in 2018 came quite a bit of funding, not what everybody wanted, it's fair to say, but quite a bit of funding, and also a promise to carry out by central government to carry out a number of reviews on the impact of the HRA. And with that in mind, both the Select Committee in Parliament and the government have produced their versions of what they think the impact is and how well they're doing. And with the most recent update on the government's response to the call for evidence on the impact of the Homelessness Reduction Act, they published an independent report dated March 2020. I've said 2017 for some reason in the paper, I apologise. For those who want to follow me in the paper, I'm at page 16. And a reminder that's downloadable from the chat panel. So the report from March 2020, which we've only just seen, gives us a little bit of information as to how local authorities and what they call service users are, what they think about the Homelessness Reduction Act and its new provisions. Well, on the assumption that I'm mostly talking to housing lawyers, you won't be surprised to see what is said. I'm going to pick out 5 or 6 topics. The first is assessment and PHPs. What do local authorities think about it? Well, their views are relatively broad. Some see them as of little benefit, but an additional workload. And you'll not be surprised to see that reports saw quite a difference of opinion between metropolitan boroughs such as those in London and those perhaps more in the shires. Other local authorities saw them as PHPs having quite a bit of value, clarity, consistency, establishing realistic expectations from those who are applying, and a sense of reciprocity with what they call service users. Service users themselves, the homeless, they were split into 2 camps. Most of them had little recollection as to what a PHP was, or whether they'd seen it, or they otherwise assigned no value to it, and the remainder were those who actually found them quite useful. So not surprising results there. On the prevention duty, this was seen, I think, by most people as the most successful part of, in terms of bringing out outcomes. in terms of positive outcomes. And local authorities have clearly devoted most of their resources, as they did before April 2018, most of their resources to preventing homelessness, to try to keep the applicant where they are at the time. Relief duty, and it in part correlates with what I've just said. The relief duty is, the outcomes were very much said to depend on the affordability of the supply of housing stock, and indeed the lack of housing stock, and indeed in some cases on the complex needs of those people who are applying as homeless. And those three issues, unsurprisingly, were said to lead to rather poorer outcomes. What about the general advice and information duty? Well, the report seems to suggest that actually these haven't really been updated from the pre-2018 days, that the advice and information that has been given was already in place before the Act. And in terms of whether or not local authorities were updating what they were providing for homeless applicants, the report suggested that those examples were not as often as you might expect. Some of you will know that one of the big changes on the ground when the Homelessness Reduction Act came into force was that local authorities were required to provide case level, what they call case level data reporting, which is known as the HCLIC data. And the report gives interesting analysis. So the passage I've quoted in the paper, transitioning to the new case level data reporting requirements was described as a difficult process, especially when initially introduced. The accuracy and to an extent the perceived ease of providing HCLIC data was reported to have improved over time. 50% of local authorities also said they saw the potential value of HCLIC data in informing the design and delivery of their provision, although there was little evidence so far of it being actively used for this purpose. So of those who said, yes, I can see how this is going to help us, they don't appear to have actually been doing much to make it help them. And one wonders what the other 50% of local authorities thought about the data collection. The other bit is that the report comes out with, it does highlight those things which make the impact of the Act difficult. So the key challenge was said to be an absence of supply, the administrative burden, notably assessment of PHBs, and the volume of written correspondence required by the Act. And as we all know as lawyers, there are a considerable number of additional Section 184 decisions, for instance, that have to be put out, and a considerable number of termination of duty decisions that have to be put out. The lack of time with users, with service users, was also highlighted. Meeting the new data requirements of the HCLIC, which I've just mentioned, and the lack of funding now and in the future. And lastly, of course, the complexities that some users have in terms of their needs and how you can meet those in effectively a PRSO context. I wanted to, the last bit I was going to highlight under this topic was the LGA response to the government's view of how the Act was doing. And the LGA said that it was noted that in 2018, not 1018, 2018 to 2019 alone, councils overspent on homelessness services by a combined total of £140 million due to an increase in demand. And my understanding was that originally, this report was March of 2020, originally all the funding was due to taper downwards. I think that as Alice has indicated, that some of the funding gap is being plugged by the everyone in and what followed from that to deal with rough sleeping. I've included on this slide a case in Mitchell. I'm going to deal with this in a slightly different context under the interim accommodation. So we'll move to the next slide if that's okay. So quite a few cases in the High Court, interim accommodation applications, and that's brought up a few issues. One is the termination of the Section 1881 duty. And another is the test for when one should get interim accommodation. I'll deal with the case of Mitchell first. You will all know that Section 188 was radically revised as a consequence of the Homelessness Reduction Act. And previously, Section 188.1 came to an end when the authority had finished its inquiry, set you a 184 decision, and told you what substantive duty was now to be given. So Section 188.1 still kicks in, and it's an interim duty to provide accommodation pending inquiries. And it is still triggered if the authority has reason to believe that the applicant may be eligible in priority need and homeless. And that reason to believe, inverted commas, and may, inverted commas, threshold is often considered to be a very low threshold that should be relatively easy to meet. And indeed, that point is obviously made whenever there's a Section 188.1 challenge in the High Court. Previously, as I've noted, the duty came to an end relatively easily. Now, the duty comes to an end by the provisions of Section 188.1 itself, and they're contained for those who are not in priority need in Section 188.1ZA, and for those who are in priority need in Section 188.1ZB. I'm not going to go through all of those at this point, but I am going to just highlight Section 188.1ZA, and that's because of the case of Mitchell and Islington London Borough Council. So Mitchell was a case in which the applicant applied as homeless. He was provided with 188.1 accommodation, and the authority then sent a 184 decision. And that 184 decision, and it could have been many different decisions, but on this occasion, it was a 184 decision that said, well, you've been found to be threatened with homelessness or homeless, you've been found to be eligible, but you are not in priority need. And the end of that letter declared rather grandly that as a consequence of that, Mr. Mitchell was owed no further duty, and that the temporary accommodation had been cancelled. And indeed, there was then a review of no priority, and that was upheld as well. Well, Mr. Mitchell was not happy with the termination of the interim accommodation duty, and he issued judicial review proceedings. And he said that he was entitled to be accommodated, notwithstanding that he was no longer in priority need, or rather that he had been found not to be in priority need. And he contended that the 188.1 duty could only end in the strict circumstances set out in sections 188, 1ZA and 1ZB itself. The authority came up with a novel, I'm going to be polite, a novel argument. And it said, well, there are additional circumstances in which the 188.1 duty can come to an end. What the 188 duty only arises if there's reason to believe that the applicant may be eligible in priority need and homeless. And if the local authority no longer believes, in fact, has decided that a person is either not eligible or not in priority need or not homeless, well, the preconditions for the 188.1 duty don't apply, and that duty must immediately fall away. So they said it was perfectly possible, and indeed perfectly proper, for the authority to simply say you're not in priority need, and at that point, the duty, the interim accommodation duty on section 188.1 comes to an end, notwithstanding that 1ZA or 1ZB had not been complied with. Well, and this is useful. The High Court made a finding that the section 188.1 duty can only end in accordance with subsections 1ZA to 1A. So only in accordance with the specific circumstances in which it says the duty comes to an end. The subsections were a complete code, nor did any request or completion of the Section 202 review of the priority need decision interfere with that code. Secondly, the court said, as the authority had decided that the applicant was not in priority need, the relevant rules for termination were those in Section 188.1ZA. Section 184 decision deciding there was no priority need did not itself terminate the 1881 duty. It was merely a gateway decision that allowed termination pursuant to subsection 1ZA. There were two alternative means of termination under section 1ZA. So firstly, only if the authority has decided that the relief duty is not owed to the applicant, whether initially it says that there's no duty or whether subsequently it says that the duty has been terminated. And secondly, the authority must take the further step of notifying the applicant that the relief duty is not owed. Only then is the 188 duty brought to an end under the first head. I'm going to just take you back slightly because I've sort of rather mashed that up, so I apologise for that. So let me try again. Two circumstances in which those who are not in priority need can have the interim 188 duty terminated. The first requires two things. First circumstance. Firstly, either there was no relief, the relief duty has been rejected, or the relief duty has somehow come to an end, and the applicant has been notified that the relief duty is not owed. Now, on the facts of this case, the relief duty had not in fact been brought to an end. It was subsequently brought to an end, but not at the time that the priority need decision was made. The second circumstance in which the interim accommodation 188 duty can come to an end for those who are found not to be in priority need is contained in 1ZAB, and that requires, again, two things. Firstly, that the authority is acting before the relief duty has ended, and the authority has decided that no 190 or 193 duty will be owed to the applicant when the relief duty does in the future come to an end, and the authority has notified the application that that is what is going to happen when the relief duty comes to an end, i.e. that there will be no 190 or 193 duty. So that was the situation that applied in Mr. Mitchell's case, and the letter of the 5th of October 2019, which decided priority need, made absolutely no mention that the authority would consequently not owe Mr. Mitchell the 190 or 193 duty. It could have done so. Indeed, at the time of the hearing, the judge said it could have done so at any time in the last whatever period it was leading up to the hearing. But having failed to say, and on the termination of the relief duty, you will not be owed the 190 or 193 duty, the authority had failed to terminate the interim 188.1 duty. So lots of duties to think about. The paper is at page 19, the relevant section of the paper is at page 19. Have a look at that if I've completely confused you. The next case that I've got on the list is the case of Luria. I'm going to skip that case. It is an interesting example of the complete inadequacy of a Mohammed letter. Rarely does a court say that a Mohammed letter in the context of section 1883 applications for accommodation, rarely does the court say that the authority has failed to address a particular issue. Well, this is a case in which it did. To the extent that you can draw anything from it, hang on to it, because even if we're not meant to be quoting examples when we run these cases, it is at least something that was positive, and the facts, as it were, talk about the difficulties in that case. The two cases I did want to touch on in the context of section 188 and accommodation, the Knowlson case and the Naji cases. They cover broader issues, but both of them touch on what test the court should ask or should apply when asking whether or not an interim injunction should be made. Knowlson has a little bit wider implications, which I'll come to in a moment, but they are both worth bearing in mind in terms of seeing some of the arguments that are being run at the moment. So on the case of Nolson, this was an application for judicial review of a Section 1883 refusal, so a discretionary refusal pending review. And the initial application for interim relief was dealt with by Butcher. He refused it on the papers. Well, the applicant immediately thought, well, I'm entitled to an oral hearing, so applied for an oral hearing. And when the matter was listed before the deputy judge, the applicant said, well, I'm relying on CPR 54.143, which provides that unless an application is certified as totally without merit, where the court refuses permission to proceed, an applicant may not appeal the refusal, but may apply for the application to be reconsidered at an oral hearing. Well, the deputy judge said, well, it said that provision only applies to the permission decision, not to a decision about whether or not interim relief should be given whilst the court is considering whether or not to grant permission, or indeed whilst the court is considering the main judicial review. And the deputy judge said, well, I have no jurisdiction to hear this matter. You should have got to appeal to the Court of Appeal. Application dismissed. The claimant appealed the decision of the deputy judge, and Higginbottom LJ gave some considerable guidance on the way in which you get to your oral hearing, and indeed the circumstances in which you don't get to an oral hearing where you've been refused interim relief on the papers. So firstly, the court did have jurisdiction to reconsider the original paper refusal of interim relief under the CPR, but that jurisdiction was not derived from CPR 5412, rather it was derived from CPR 3.3. There's a slightly convoluted route to get to that. I think the thing to remember for yourselves is that CPR 3.35 is the rule you want to rely on if you're refused interim relief on the papers and you want an oral hearing. And I've set out the route you get to it at page 21, paragraph 68 of the paper. But that did give rise to a little bit of discussion from the judge as to what might happen and what alternatives there might be, and what should be on the order. And those I pick up at paragraph 68b of my paper. And in particular, the right to apply for a reconsideration can be ousted by consent. Now, I can't imagine that as an applicant you would want to oust by consent the right to an oral hearing following a refusal of interim accommodation, an injunction for interim accommodation, but it is there. If the parties consent to the matter being determined without an oral hearing, the consequent order will be final, and the route of any appeal is to the Court of Appeal rather than through a request for an oral hearing. The court also noted that theoretically your reapplication could also be requested to be on the papers, but that it is good practice, relying on the case of Collow and Williams, that the second application should always be for a request for an oral hearing, and that's to achieve some finality, as it were. And in terms of advice to the parties, a party making an application should indicate whether it wishes to have a matter dealt with orally or on the papers alone, and that gives the opportunity for the other side to say they consent to the matter being dealt with orally, so that it would be so that any order would be final. Where the court refuses an application on the papers and absent consent of the parties, the court should endorse any order with the relevant right to make an application to set aside or vary or stay the order made. Now, of course, that's a matter for the court, but when we're drafting our draft orders and making these applications, you may want to consider including that in square brackets for the court to add it. And thirdly, a party applying for reconsideration of an adverse decision should indicate the rule that is being relied upon. And as I mentioned, that rule is CPR 3.3, open brackets 5, close brackets. The court also looked at, moving on to a slightly different issue, the threshold that needed to be achieved for an applicant to successfully obtain the grant of interim relief. Now, historically, most people are taught that the test is because you're asking for a mandatory injunction rather than a preventative injunction, that we're usually told that the test is a strong prima facie test. And the court looked at the history of that and noted the cases of DeFalco and indeed the case of Francis in the Court of Appeal. So that, and that's where the more onerous strong prima facie test comes from, where you're asking for what's termed a positive injunction, a mandatory injunction. The applicants in the case of Nolson raised doubt about whether that was the correct test. And if nothing else, Nolson is a useful way of finding out what that doubt is, because the court goes through it. And in particular, it notes the case of Esposito in Camden, where Jay had doubted the usefulness of the dichotomy between strong prima facie case and arguable case. So is there a lower test? Does that lower test make any difference? There was some discussion in that case. And indeed, there's some suggestion that Francis may have been per incuriam in the Factortame and the National Commercial Bank of Jamaica case were not referred to, both of which eschew the idea that there's some difference between a positive, between how you approach a positive and a negative application. So was Francis per incuriam? Well, given that the court didn't need to, you'll not be surprised to hear that Higginbottom J, just on a permission application, declined to give his view as to which was the correct test. That issue came up again in the case of Naji. Now, Naji was a case, again, which was using the very low 1881 threshold, reason to believe that maybe, and in this case it was priority need was the issue. I won't go into the facts of the case. Basically, the judge did not think that the medical evidence was strong enough to suggest that even that threshold necessarily meant the authority had to find there was reason to believe. But it is clear from that judgment, it's a High Court judgment, to that extent it is binding. It is clear from that judgment that this court took the view that the strong prima facie case threshold was the correct threshold. And to that extent, given that it was a negative judgment, it is potentially binding at first instance. So those are the cases on thresholds and application termination of duties. Two additional cases on suitability of accommodation. I'm conscious it's 4:05 and that if you're still listening, I'm both grateful and surprised. But I do want to try and cut through some of it. Of those two cases, I'm going to take the case of Escott, but not TMO. And on the case of Escott, this was a case in which the applicant was provided with Section 188 accommodation, but the issue was whether or not it was suitable. Mr. Escott had certain conditions, and the argument was that he had to isolate from COVID-19, and that therefore a shared accommodation wouldn't work. And indeed, if he was going to be provided with a self-contained accommodation, it should be furnished. And that argument came up because, in fact, the local authority, in something of a rush, it's probably fair to say, was only able to provide unfurnished accommodation. Now, between the date of the original application, the JR, and the subsequent hearing, I think the local authority made strenuous efforts to try and get some furniture in. There's suggestion that the housing officer even produced a match of his own for the applicant. And prior to the hearing, it seemed that the applicant had a microwave oven, 2 separate mattresses, a sofa, a kettle, and had been offered a fridge freezer, although he said that was a health risk in for various reasons. So it wasn't actually in the property. And there are two aspects to which ought to be highlighted in the case. Firstly, the general proposition. It was argued by the applicant that as a matter of general proposition, the provision of unfurnished accommodation would necessarily mean that the accommodation offered was not suitable. And the judge in that case thought it was of particular significance that there was no authority suggesting that accommodation was only suitable if it was furnished, and he rejected that wide proposition. On the specific facts of the claimant himself, and it's clear from the judgment that the claimant did have particular worries, genuine worries about what would happen if he was unable to isolate. On the specific facts of the claimant, the judge also took the view that accommodation wasn't suitable. The bar to be met by the claimant was a high one, whilst his personal need to isolate in the pandemic might be one factor against it being suitable. The sheer weight of demand placed on the authority by the demands of the pandemic was a counterweight. On the facts, it could not be suggested that a microwave, a sofa, and mattresses were not sufficient. The absence of a fridge or a cooker or a bed could not seriously render the accommodation arguably unsuitable. So rulings both a general proposition and examples of a case in which somebody who needed to isolate was provided with accommodation, notwithstanding that it wasn't completely furnished. I'm going to turn to the next slide, if I can, to the main housing duty, the Section 193 duty, the most that we can get out of Part 7 itself. Three cases there. The first, I'm going to skip if I can, but it is a good example of a factual case in which the court was clearly of the view that suitability threshold had not been met. And it's also an example, if I may say so, of a colleague, Lindsay Johnson, finding some considerable ingenuity in how to make the authority accept a duty, notwithstanding that the client had refused accommodation elsewhere. However, if I can give some attention to the case of RM and Newham. This was a case in which the authority owed a Section 193 duty, and the facts are relatively stark. The applicant and his wife had 4 children, so 6 in the household, and the applicant's daughter had a number of serious disabilities which required additional space for her and a room of her own. The authority had accepted a duty and the family had lived in 1932 accommodation for 13 years. In 2017, because the children were growing, etc., and space had become a real difficulty, they asserted that their home was not suitable. And the authority offered alternative accommodation. They accepted that accommodation, but they said it's still not the new accommodation offered wasn't suitable, and they applied for a review of the suitability. On review in February 2018, the authority accepted that the new accommodation was not suitable. So they accepted that the 193 duty was owed, but that the accommodation currently being provided was not suitable in the context of that duty. Despite that, they made no alternative offer for over 2 years. And in September 2019, the applicant clearly had enough and issued a JR proceedings for an injunction requiring the authority to secure suitable alternative accommodation. The authority raised a number of arguments, but probably the one that had the best chance was the argument that even where the authority accepts a duty, and even where the duty is to provide suitable accommodation, even where it's not providing suitable accommodation, there is no breach of that duty unless a reasonable period of time has passed to secure the accommodation, and consequently, in this case, the authority argued on the facts that notwithstanding the 2-year passage, that a reasonable period of time had not elapsed, and that the duty had not been breached. Consequently, the JR should be dismissed. Alternatively, they argued if they were in breach, relief should be refused because the authority had taken all necessary efforts to provide accommodation but had failed to do so. Well, the court dismissed that defence and made an order that suitable alternative accommodation should be provided within 12 weeks. And I want to draw out, this is at page 29, the 3 of the main elements. Firstly, despite conflicting authorities, this is at B, the court preferred the view that if accommodation was not suitable for the purpose of section 1932, the authority was in breach immediately. There was no reasonable time within which the authority could find accommodation and avoid being in breach of the section 193 duty. Even if there was a reasonable period to find accommodation, the reasonable period for compliance had long since elapsed on the facts. The family's difficulties with accommodation were considerable. The time since the decision in 2018 that the accommodation was unsuitable had been over 2 years. The authority had purported to give the family purported to give the family a high priority, despite which there had been no offer of accommodation. And the evidence submitted regarding the efforts made by the authority to find accommodation suggested no real coherent thought applied to the applicant's situation. And there had been no satisfactory explanation given for the delay. On the question of relief, so judge found whatever test you applied, you're in breach. And on the question of relief, the authority still said, well, hang on a second, we've tried our best. The judge picked out the 4 important factors to be considered on the question of relief: the nature of the accommodation occupied, the length of time of any breach of duty, the efforts made to remedy the breach by the authority, and the likelihood of any accommodation becoming available, and anything else that might be relevant. But not surprisingly, given what I've just read out, the judge took the same view on the question of relief and said all those factors pointed to the grant of relief in this case, as the authority hadn't done enough or given evidence to show that they had done enough on any stretch of the imagination. So that is the case of M and Ewan, which is extremely useful, particularly since I think I can count about 3 or 4 cases in the last 12 months that I have done in which the authority is clearly in breach and is just saying we can't do anything. And that case is, I think, going to be extremely useful as a summary of what the position is and of what the authority should be doing. A quick touch on out of area placements, a topic that I still find hard given what happened in the LibCat. But the case of Broderick was an attempt to attack the, if I can call it, to bring up one of the temporal issues, the fixing of time, and the suggestion that, or the question, what is the relevant period of time that the authority has to look for alternative accommodation? Is it just the date of the offer? Is it some other time? Should it be over a period of time? Should they wait and see if something comes up? Instead of sending somebody out of the area. Just checking the time, I'll do a little bit more if I just continue a little bit if I can. But the essence in the case of Broderick was that the relevant time for determining what else might have been available when deciding whether or not there was alternative accommodation closer to the authority than, in this case, I think it was Gillingham, when the authority was Bromley. The relevant time is the date of the offer. However, there is a distinction between those cases where the applicant refuses accommodation and those cases where the applicant accepts and then asks for a review. Where the applicant refuses accommodation, as in the case of Broderick, the relevant time is the date of the offer. Council in that case suggested, well, maybe it should be 5 days around the date of the offer. You should wait a little bit, a period of time. Court said no. What's available on the day is all that matters. Otherwise, it just becomes impossible. Compare that with the case of Sally, which is in the paper, where the applicant accepted the accommodation, asked for a review. Well, in that situation, the relevant date is the date of review, and the date and the authority is required when considering whether or not it's appropriate to put somebody in Birmingham, for instance. The authority is required at the date of the review just to see if there's anything that's come up closer than Birmingham or wherever it might be. So a distinction between those who accept and those who refuse, and not surprisingly, the Court of Appeal in the case of Broderick said, can I just remind everybody, if you are offered accommodation, please accept it and then review, do not refuse it. There's just on the next one's reviews and appeals. Oh, help, 4:15, my apologies. I think Al-Ahmed can be dealt with relatively shortly. LB and Tower Hamlets has already been dealt with by Alice, for which I'm grateful. Al-Ahmed and Tower Hamlets on appeals is quite important. This is late applications. High Court judge said, sorry, County Court judge said, I've got evidence here. The applicant says just couldn't find a lawyer, therefore was a month late. As soon as lawyers managed to get lawyers, the appeal was put in 2 days. High Court judge said, these things aren't complex. You don't need a lawyer. I'm overturning this, and said that an applicant could have put in the applicant could have put in the application or the appeal themselves, and the delay was therefore not good enough. And the test, of course, is whether there's good reason for the delay. Well, the Court of Appeal overturned that and restored the order allowing the appeal to be put in late. And the main key points are that whether there is good reason depends on all the circumstances of the case, the absence of relevant lawyers, and the complexities of housing cases were relevant to deciding whether or not to extend time. And indeed, they noted the evidence from Shelter, and they disagreed somewhat forcefully with the High Court judge's view that a lack of representation and the need to seek legal advice were irrelevant. They were not. Gill and Camden is an example of a refusal of permission to file late. It's only in there to show you just how bad things can go, and I'll leave you to read it at your leisure. Case of James and Hartmere is a contracting out case. And again, I'm conscious of time. It's another contracting out case, another case in which the council immediately got their evidence in and said, well, we're going to ratify any contracting out. In this case, it was a company called IMG. So the contracting out issue, for those who dealt with it before, is to do with the whether or not companies can carry out review decisions and whether those review decisions are lawful. And it's fairly clear that Court of Appeal is not likely to find these cases very positive. In this instance, the real relevance of this case is that the court looked at the jurisdiction of the county court in Section 204 cases. It was argued that actually the issue whether or not there had or hadn't been a proper contracting out of the to this RMG company for review decisions was not something county court could look at. The court said absolutely it is. And indeed, it looked at them as that said, well, you can even challenge policies, and it effectively said that the county court jurisdiction in Section 204 can look at the full range of issues that would otherwise been dealt with by way of challenge in judicial review. So that's the importance of that case. Stanley and Welland Hatfield, I probably am going to have to cut short, but that's a case which is worth looking at. And in particular, it deals with the situation where you don't get a review decision in time. You have to appeal the original decision. You then get a review decision which you don't like. Well, can you just carry on with the first decision, or can you do you have to deal with the second decision. It was argued in Stanley that the second decision is a nullity if it's not in time. And the Court of Appeal said, no, that's not right. And that where you've got two appeals, you effectively are appealing the review decision. Slightly unclear, because they don't expressly say so, what would happen if you simply appealed the first decision, the 184 decision, and then but did not appeal the 202, the out of time 202 decision. But I think it's fairly clear from the ratio that the court would be forced to deal with any appeal on the basis of what was said in the review decision, not in the original decision. There is still some space, some scope for the court looking at the first decision, i.e. dealing with the appeal of the first decision, where there is a legitimate interest for doing so. I try to think of what facts might arise, and I've suggested the case of Robinson. I've put the reference in. Facts of Robinson might be such a situation. Apologies for the slightly quick rant at the end, or sort of gallop at the end. Hopefully that made sense. If it didn't, my apologies. And I'm sure the paper will be better than what I've said.
Thanks very much to both of you. And now, with apologies for having gone slightly over, we're going to move to any questions. We've got 2 questions so far in the Q&A, which I'll just read out for everybody and then hand over to the panelists. But before I do, just a reminder that the links to a copy of the paper have been posted in the chat function, so they're there if you've not found them already. So the first question that we've got is whether it refers to the announcement on the 8th of January from Robert Jenrick of additional funding for local authorities, and then being asked to redouble their efforts to accommodate all of those sleeping RAF. And the question goes on, does this mean that if someone is non-priority need and homeless, the council should be accommodating rough sleepers so as to prevent a public health COVID risk? And so I turn that to Alice first, in case you've got any.
Sure. Yeah, I think my reading of that announcement from Robert Jenrick is that, yes, that would be the case, because everybody's meant to be in, everybody in is in theory never gone away. They keep telling us that, although as I say, there's been a sort of a shift in emphasis over time. And certainly if somebody's a non-priority and homeless, we would be expecting for them to be in emergency accommodation. Initially that would have been hostels and hotels and other things, although as time has gone on, those arrangements have changed. I think the difficult question, which isn't quite what you've asked, but I think is an interesting tag on, is what about somebody who's not eligible under Part 7 following the 8th of January announcement, because that announcement hasn't said anything about what to do in relation to people who aren't eligible. And that's the key point raised, as I say, by the National Audit Office, saying that's really unclear. What government are you going to do about these people who are brought in under everyone in? Some of them have already lost that accommodation and are back on the street. And there's no clear kind of guidance or idea about whether or not they can now be accommodated following this 8th of January announcement. So I think that's the tough question. I think for somebody who's eligible and non-priority, they should be being provided accommodation in line with this government announcement. Does everybody else agree with that, or contrary thoughts?
I think that's right. I haven't seen whether JN and Brighton and Hove is based on legitimate expectation, but I assume that that's the ground that, absent any discrimination, that you would be running in terms of why those letters entitle you to something. This is a policy directive to councils, and indeed the council are then required to produce plans, if I remember rightly, which set out what they will then do. So you get 2 policies in effect, and some councils may be more generous than others in terms of their policies. And those policies are published, and then they generate legitimate expectation. And the degree to which you can use that legitimate expectation will depend on the caveats included both in the letter and in the subsequent policies. But the big caveat is that, as Alice says, it doesn't appear that those who are not eligible are being re-included in a way that one might have hoped. And hence the reason why we're all kind of looking at the Brighton Hove case to see what happens.
Yeah, I understand at least at the interim, there was an interim decision in the Brighton and Hove case, and there's reference to that in the paper. At that point, they're talking about legitimate expectation. I don't know if it's run in that case, but I would have thought that in other cases as well, you'd be looking at potential human rights breaches if somebody didn't, accommodate a person, if you've got the right kind of factual scenario. So that might be another way to kind of, if you've got the power to accommodate, to leverage and say that it should be, they should be accommodated. But again, that's going to be very factually dependent.
And I suspect in those cases that you'll be looking for disclosure as quickly as you can of what that particular authority has done in response to the letters that have been sent out by government.
Exactly. They should have a policy. I think there's another one. I know, Dan, you're manning the sort of the question answer fort, but I might just, being aware of time, crack on, which relates sort of similarly to COVID-19 and this idea of when somebody's vulnerable, and that's whether if someone is obese or an ethnic minority and therefore likely to suffer greatly if they catch COVID-19, could it be argued that they should be in priority need, or do you have to have a medical issue? I don't think we've got anything that directly addresses this point in terms of the authorities that we've seen, but if we go back to the wording of the edit to Chapter 8 of the Homelessness Code, which is at page 7 of the paper, there is quite a strong and close emphasis on health conditions rendering somebody vulnerable or extremely vulnerable. And it may be that you don't have a letter from the GP yet, but that you have a condition you can identify. And as I say, I think you could potentially, with the right facts, if you could put forward the facts in relation to the individual, say that obesity might be a basis for saying that they've got a vulnerability that needs to be taken into account. But I think it's going to be highly factually sensitive. And I think coming out of both that update to the Code of Guidance and then also the approach to the court in Bancol-Jones, I'm not sure that blanket submissions about anyone who's obese generally is going to be in trouble are going to work. And I certainly think that there's going to be likely be difficulty making any kind of arguments along, well, this racial group or this ethnic group as a whole are in potential risk, rather than focusing on, well, what about the profile of this individual means they're at risk. So I think that latter kind of argument would be very, very difficult to make indeed, in light of the strong steer that this has to be grounded in individual evidence about the applicant themselves, and the kind of Bancol-Jones, that they're very clear that they don't want to be introducing new tests or new distinctions into the legislative framework. So I would have thought the answer would be to focus quite closely on the particular profile of your individual applicant and see what evidence you can gather in relation to them as an individual to try to bolster a claim for vulnerability.
The vulnerability of ethnic minorities is an interesting one, because to some extent that would need to be evidence one way or another. And I think back in April or May, when that evidence first came out, we might have been in a better position because there was a real uncertainty about the statistics. Since then, people have put forwards, or papers have put forward different ideas as to why race is a factor. Is it actually an economic factor? Is it actually a poverty factor? And so you would imagine that if you brought it just as that local authorities would be seeking to discredit the evidence itself. Whereas, as Anna says, if it's looking at the individual and that is part of the picture, so there's both a medical condition, there's a poverty condition, and you can bring more factors in and say, well, because this individual has these particular problems, then I think you have a better chance.
Thanks very much for the two of you on those questions. I think, one final thing to add in relation to the question of obesity that was raised, whether obesity is enough or whether a medical condition is necessary. A quick look. First of all, it's clear from 1891C that it's physical disability or other special reason that must be the reason for vulnerability, and other special reason has been interpreted quite widely. And certainly, I think there are cases. I just had a quick look with the case of Sims and Islington, in which obesity was mentioned as one of the medical factors. So I think if you could show that led to vulnerability, you might be all right. Conscious of the time, there are a couple of further questions in the Q&As. The first is about what happens where a local authority has provided accommodation and then has terminated accommodation on the basis that the applicant is not homeless but hasn't provided a Section 184 decision in relation to that. It seems to me the quick answer to that is, the question says there's no Section 184 decision, so no right to request a review. The quick answer is that you bring a judicial review of the failure to produce a 184 decision, and in the interim the Section 181 duty won't be properly discharged. But I don't know whether Dominic or Alice, you want to chip in with anything additional. And then the final question that's come through on the Q&A is about, it's the question of whether, while you have an appeal live, it's possible to bring a fresh application. I don't know whether either of you wants to offer any thoughts on that at this stage.
Yeah, I mean, so local authorities love to say you can't bring a fresh application whilst I've got an appeal, but that seems to fly in the face of Rickabagan, to my mind. If the application is not on the same facts, and remember that the review decision will determine what those facts are. In other words, that's the point in time at which you know what the authority did or did not have to address. If subsequent facts, let's say it's a priority need case and you've got new information, as is often the case, then putting that new information in, particularly the case that Alice referred to earlier on in her talk, putting that new information in, absolutely, it seems to me, entitles you to make a fresh application, notwithstanding the appeal. Where you might get into difficulties is in relation to costs and the degree to which the court may be relatively comfortable criticising you for not, for instance, pursuing the other application or pursuing the appeal or whatever it might be. But just, if you, sorry, go on.
I was going to say, just an additional reference on that. There's an older case, Conadiba and Kensington and Chelsea, which, in addition to Bucartic, suggests that it is possible to make a fresh application during the course of an appeal. But yeah, sorry, Dominic. I thought.
No, I think the issue is whether you end up with criticism and whether you end up in difficulties on cost, which can be a big issue in these cases.
So I think that's everything that we have then in relation to questions. There's a further comment really that's come through in the Q&As, which said that many local authorities appear to be returning to priority need regardless of lockdown 3, in my experience at shelter over the last year. So I mean, it's useful to have that kind of feedback from the front line, and it'll be interesting to see whether things play out during this lockdown as they have in relation to the previous lockdowns. But with that, unless there are any further questions or any further comments from either of our panelists, I'll finally end with thanking both Dominic and Alice very much again for their presentations, which I found very helpful and informative. And thank you everybody for attending. Thanks very much. Bye-bye.
Thank you.
All right. Cheers.
Bye.